I must begin this evening by thanking Susan for her leadership over the last 2 years. 2 years ago, when Susan took over as the president of the New York City Bar Association, she issued a call to action to confront the many crises that were facing our city, our country, and our world. And over the last 2 years, Susan used the imprimatur that her position gave her to respond loudly and clearly to these challenges that our city, country, and world have been facing. At times, Susan presciently drew parallels between what is happening in our world to her parents' experience in Nazi Germany. Those parallels remind us that we cannot be normalized to the attacks on our civic institutions and on our rights. Susan, you have left some big shoes to fill. My bond to this particular association goes back to 20 years. When I was a first-year law student, I came here for an interview for the position of student research assistant, and I met with Steve Greenwald, the then chair of the Capital Punishment Committee. At that time, I was driving a livery cab in the evenings, and I couldn't find a parking spot for the cab, and I recall the anxiety I felt when I realized that I might be late for the meeting. And rather than dismiss me, Steve waited for me, he interviewed me, he hired me. If Steve had not been patient that night, perhaps I would not be standing in front of you tonight. It is here at this Bar Association that I had the privilege of working on committees with Norman Green, who's here tonight, with Ron Tabak, who's here tonight, with Jeff Kirkmeyer, with Steve Bachman, Greg Camp, and Jason Gould, and Kate McMahon, who are here tonight, and many other generous lawyers to whom I am indebted. They reminded me, these lawyers, they reminded me through example of the special obligation that lawyers have to practice law in the service of the public good. In a lecture in this great hall in 2007, Judge Jack B. Weinstein, from whom I had the honor of clerking, emphasized that in the practice of law, we cannot lose sight of empathy, the appreciation for the welfare of those affected by the law. He said, we must try to open a dialogue between the heart of the law and the hearts of those who seek justice. I am grateful to the many family members, friends, and colleagues from my firm, Patterson Belknap, who are here tonight. I am honored by your presence. My wife, Lila, who's here, is a model of patience, empathy, and kindness, while juggling her own career and raising our 3 wonderful children, Zafar, Salma, and Kareem, who have managed, to my surprise, to stay seated without their phones tonight. Lila somehow finds the energy to help kids in foster care, and mothers struggling to get their lives together after being reunited with their children, and refugees who recently escaped the brutality in Afghanistan. The list is long and I can go on. She receives her inspiration from her parents, Claire and Barry, who are also here tonight. But perhaps no one has been looking forward to tonight's events more so than my parents, Munir Fatma Faridi and Ashraf Faridi. I am humbled by their struggles in coming to this country to make a better life for their children. I admire their bravery and fortitude in leaving behind their home country, their family, their friends, to build a new life in this country, very far and very different from home. My father so badly wanted all of his friends in Pakistan to see me tonight that he asked half of our ancestral village to apply for visas at the US consulate. I see that some of them have made it through here. And my sister Aisha, and my brother Salman, and my sisters-in-law, and my brothers-in-law, they are excellent role models to our children They have given Lila and me steadfast support over the years, and they are wonderful parents to their children, Iman, Ali, Parker, Lily, and the newest addition to the list of cousins, Safa. As Susan said, we live in a challenging and troubling era. There is global conflict and upheaval in our own country, the rise of nationalism and white supremacy, the assault on the rule of law, democracy, reproductive rights, and voting rights, the attacks on our brothers and sisters in the LGBTQ community. With so much happening in our world, it has been rather difficult for me over the last couple of weeks to identify my priorities as this association's president for the next 2 years. The list of barriers to equal justice and due process is long, and our time and resources are limited. Luckily, as a result of this association's illustrious history, the position of presidency offers a bully pulpit. And over the next 2 years, I will continue to support the work that my predecessors have started, support the work of our committees and task forces, and continue to advance the association's mission. In doing so, there are 3 areas that I believe warrant special attention tonight, and where I think we can together make a meaningful difference in the next 2 years. The first area is the shortage of judges in New York State Supreme Court. This is an issue that Susan spoke about earlier. And this shortage largely stems from the constitutionally prescribed method that limits the number of justices in each judicial district. To address the backlog at the Supreme Court level, our court system ends up, as our Council on Judicial Administration recently called out, robbing Peter to pay Paul, placing criminal, family, and civil court judges into the Supreme Court on an acting basis, which further depletes the much-needed resources at the lower courts. We need to develop a modern, evidence-based method for assessing judicial needs throughout the state. And although complicated and controversial, we also need to reevaluate the need for 11 separate trial courts that we have in our state. This maze of courts often causes a single dispute to be litigated across multiple tribunals. In my view, the process delays the administration of justice and drains our state's resources. The fragmentation and backlogs erode the public's confidence in our judiciary, and with that, in the rule of law. The people of our state and the businesses that litigate their disputes here deserve a modern court system. For too long, ideas to meaningfully reform our courts have arrived with great fanfare, then fizzled before any changes can be made. The Association's Council on Judicial Administration has already begun to do the hard work. We need to stay the course until real change is made. The second priority is a more diverse profession for the future. The list of people who have stood in this great hall to implore the profession to do more on this front is long. It includes Conrad Harper, whose efforts in the late 1980s led to the issuance of the precedent-shattering Statement of Diversity Principles in 1991. Ruth Bader Ginsburg spoke here in 1999 and implored the profession to do better in her lecture on affirmative action. Eric Holder spoke in this Bar Association in 2001, and his lecture was titled, "The Importance of Diversity in the Legal Profession." Progress has been made over the last few decades, with much thanks to the efforts of the various pipeline and fellowship programs of this and other associations, private law firms, and in-house law departments. Our association's Office for Diversity, Equity, Inclusion, and Belonging, which was set up 20 years ago, has helped with the strides that we have made in fostering more diverse and inclusive environments. But notwithstanding the great and heroic efforts Diversity in the legal profession still falls far behind in comparison to other professions. Only 19% of attorneys in our country are considered minorities. Compare that to 36% of physicians and 30% of dentists who consider themselves to be minorities. The numbers are even more striking in law firm partnerships. Only 12% of law firm partners are minorities, and just 28% are women. These numbers confirm that we have a lot of work to do. If we want the public to have confidence in our system of justice, then the faces that represent the profession, lawyers and judges, have to better reflect the diversity of our society. Unfortunately, the efforts for a more diverse and inclusive society are under attack. The backlash is predicated, in my view, on the false notion that people succeed or fail on their own merits, and that past inequities and biases do not have an impact on the outcome. But now is not the time to retreat. It is time to reaffirm our commitment to diversity, inclusivity, and equity. On the front end of the process, law schools need to continue to improve their outreach to diverse candidates, and they need to reevaluate admissions criteria, such as standardized testing and legacy preferences. Law firms need to recruit from a wider array of law schools and question their elitist tendencies. The data show that the advantage of higher LSAT and academic pedigree diminishes rather than compounds over time. And as Conrad Harper recently observed, it is easier to recruit than to retain, and easier to retain than to advance. Employers need to train and nurture diverse lawyers with the tools to advance in the profession. Law firms need to actively look to promote diverse lawyers into partnerships, help them develop business, put them on management committees, and make them heads of departments and managing partners. In-house law departments can encourage these efforts and demand accountability when they do not see progress. The third area is to prepare our Bar Association for the future generation of lawyers. While our association's membership is 22,645 members strong, the reality is that Bar Association membership across the country is falling. In my view, that is largely because the new generation of lawyers struggle to understand the value proposition of the Bar Association. They perceive, rightly or wrongly, that bar associations have not kept up with the advancements in technology, networking, and that the associations do not fully capture their views on social justice. And these issues will compound as future generations enter the profession. I am not personally opposed to the sunsetting of ideas and institutions, no matter their historical significance, if they become quaint or obsolete. The proper place for relics is in the history books and museums. But the Bar Association as an institution, and not just this one, but others as well, is indispensable to the future of our profession. If it's not this august institution, which organization will mobilize lawyers, as Susan did, when an executive wants to use up funds in the IOLA escrow accounts that are designed to provide legal services to the needy? Which institution will stand up for judges who are attacked for making tough decisions that the politicians do not like? And which institution will stand up for highly qualified nominees for the bench who are vilified on the basis of their heritage and for the pro bono work they've done on behalf of civil rights organizations? Which institution will hold judges on our high courts accountable when they issue decisions that are contrary to our constitutional principles of equal protection, due process, and the prohibition against cruel and unusual punishment? Which institution will mobilize lawyers to represent death row inmates on a pro bono basis? Let me provide you with one example of an area where our Bar Association can engage with the next generation of lawyers. You cannot attend any meeting of professionals, whether it's lawyers or physicians, where discussion of artificial intelligence or AI is not on the agenda. We attended a day-long retreat on Friday at Patterson Belknap on AI. As was the case with computers, I accept the fact that the legal profession is not going to be on the cutting edge of this particular phenomenon. I am told on good authority that some judges still use faxes and WordPerfect and even notepads and pens. We need, of course, to discuss the practical issues, such as how to incorporate AI in the process associated with the provision of legal services. The association's task force on digital technologies and our other committees have already begun that process. But we cannot stop there. We need to engage the next generation of lawyers and the public at large on the more fundamental issues related to AI. In my view, the law is where ethics and morality interact with the regulation of human conduct. It is thus incumbent on the bar associations to facilitate a dialogue among scientists, software and machine learning engineers, ethicists, public intellectuals, academics, and policymakers about the critical considerations of AI. For example, whether and how to regulate AI that generates content that amplifies existing biases, whether and how to regulate AI that may lead to the further isolation of our children. You have seen the movie Her with Joaquin Phoenix and with the voiceover from, who's in the news recently, Scarlett Johansson. Whether and how to regulate the use of AI that impedes human freedom, choice, and autonomy, for example, by manipulating employees to work longer hours. Whether and how to regulate AI that may pose an existential threat to our world. We have all seen the Terminator series of movies. Whether and how to regulate the use of AI to create deepfake content that could sow discord and weaken public confidence in our institutions. And lastly, whether the dependency on AI enhances fundamental aspects of our shared humanity, such as creativity, critical thinking, and problem solving, or whether it leads to their destruction. In my view, there is no institution than the Bar Association to lead a dialogue on these issues. And in doing so, it will not only avoid obsolescence, but will remain a critical resource for lawyers and the public at large. As I have in the last 20 years, I will value every moment that I walk into this building. Now the hard work begins, and I look forward to all of you joining me in these efforts. And I will continue to appreciate the kindness and forbearance of Lila, our children, my friends, and my colleagues at Patterson Belknap. Thank you for joining us this evening, and please join us for a reception across the hall. Thank you.